Making it work takes a little time. Making it work takes a little longer. Making it work.
With the legalization of marijuana for recreational use looming, there is one sector really under the gun to prepare, and that is employers, says well-known employment lawyer Shelley Brown, who joins us in studio this evening. Welcome to What She Said.
Thank you. It's a pleasure to be here.
Now, so far the conversation has been focused on all sorts of things like distribution and the protection of young people, but the workplace is the area of concern to you, Shelley. What are the challenges for employers? And I know that they're huge and plenty and just beginning.
Yes. Well, you could write a course on this topic, and so it's difficult to sort of diffuse it down to a couple of words, but the major issue is impairment in the workplace. And there are two difficulties with respect to that. One is the issue with respect to medical marijuana, which is not really what we're talking about here. And the second one is that there is no equipment that is comparable to a breathalyzer that establishes actual impairment at the time that the test is administered. And there are certain protections that exist in the law, even for those who don't have a medical basis for taking marijuana, that make it very difficult for employers to discipline their employees.
When you said that we weren't talking about medical marijuana here, is that because the THC, the active, is maybe lower, or how would you know if somebody's approved for medical marijuana and they are still vaping in the workplace?
Well, firstly, medical marijuana is now sort of on the same level as any other prescription drug. So in that regard, all they need to get is a prescription. But the reason I indicate that it's different is because under the Ontario Human Rights Code, there are protections that exist for those who have disability, and that would also include whatever drugs are necessary to deal with that particular disability. Whereas for recreational purposes, it's similar to alcohol. Mm-hmm. And so with respect to alcohol, you have a breathalyzer, and that establishes at the time that the test was administered that the individual, and if it's administered at work, the individual was obviously drunk, and therefore discipline or policy procedures that exist to relate to that particular situation can be applied. It's not the same with marijuana, because marijuana, the THC, as you referred to, actually stays in the body for longer periods of time. And even if a person hasn't actually ingested or smoked marijuana at the time the test was administered or even shortly before that, it will still show up. And that does not indicate actual impairment.
Is it a urine test? Is that what the THC
Well,
test?
there are several different kinds of tests. There are saliva tests. There's urine tests. There's also blood tests, which is a pretty intrusive type of test. None of which can actually establish at the time the test was given that the worker was impaired.
So what is the law now in terms of substances that cause impairment? And I'm assuming we're talking about alcohol.
Well, with respect to when you talk about the law, there are so many different regimes that apply. But basically, the situation is that in the workplace, the employer is able to establish certain rules and regulations, subject to obviously what the Ontario Human Rights Code or human rights legislation across Canada requires. But with respect to recreational marijuana or recreational drugs, an employer is able to say you cannot use that. You cannot be impaired in the workplace, and if you do, your job is in jeopardy potentially. There are mediating elements such as privacy rights. If the person is considered to be dependent, there's also a protection then under the Ontario Human Rights Code. So it doesn't always apply.
But let me ask you, should there be different rules for different groupings in that the risk of a crane operator being high is not the same as a sales clerk?
That is true. And basically the legal regimes recognize that there's an important element to avoiding safety sensitive or making sure that there are not accidents that occur for those who work in safety sensitive jobs. However, there's a balance that the courts try to establish, and that is to protect privacy. So in other words, if you use marijuana on your own time and it still shows up 2 weeks later in a test, you are not necessarily impaired at the time you're working, even if it's a safety-sensitive job. And so these balancing acts then come into play with respect to the policies and procedures.
Well, it sounds like employers need to tread very carefully.
Yes.
And they need to get prepared.
Yes.
So what should they do?
Well, I think employers have to do a couple of things. Firstly, they should look at their current policies and procedures and see how they reflect the current reality. And whether or not they're responsive to all of the decisions that have been rendered relating to these particular issues. The second thing that they should do is then look at their workplace and define specifically what areas are safety sensitive and which are not, and then revamp their policies and procedures in order to reflect what the workplace really is and what the current law is with respect to now the new regime with respect to recreational marijuana, which will actually become legal next Canada Day, and also with respect to all of these decisions, so they can take action that is appropriate and that is helpful in terms of safety-sensitive positions.
Now, something that has happened is, and this is in regards to random testing, this was a court case,
yes,
and the transit union vehemently opposed it, and they lost. They
Random
were
testing.
ruled
Yes.
against. So tell us quickly about this and what the repercussions are.
Well, actually, it's really interesting because 2 individuals were fired just today in the Star. There's a story about that based upon the random testing. But basically what it is that there was a policy that was put into place about 8 or 9 years ago by the TTC, and the random testing aspect of it was held in abeyance. They put it into play a couple of months ago, and that's what generated this injunction attempt. And what the courts essentially did very quickly was, or the court did very quickly, was that it basically said, look, the safety aspect. So I'm really bearing this down to its bare
absolutely,
bones.
absolutely.
The safety aspect trumps whatever supposed damage may occur to the employees. In terms of reputation or stigma, privacy, and that type of thing, and I think the judgment is really interesting because it talks about all of the issues that are going to be significant going forward in terms of those policies and procedures that you're talking about, and what the courts are going to look at, and what the tribunals are going to look at, and what the arbitration boards are going to look at going forward.
Now, do you see just a slew of court cases coming up where employees and unions are going to challenge the law?
Well, I think it's inevitable that that's going to be the case because, in a sense, we're treading on new ground. And what the law typically does when there are, there's essentially a huge void is fill in the blanks based upon ongoing challenges, such as the one that the TTC was involved in just recently.
And yet there would be people who would say, well, how is it much different than booze?
Well, it is different in the sense that, again, it's a technical difference and a practical difference, and that is that the test that exists for booze, the breathalyzer tests, can show that the individual at work is drunk and therefore is legitimately subject to discipline. Whereas when you give somebody or administer a test to determine whether or not they are a marijuana user, and really that's all that it establishes, it doesn't test actual impairment at the time, and that's a problem.
So who's coming up with the new test? Because somebody should be working on that.
Well, I think firstly it would be incredibly economically beneficial to whoever does. There are people that are working on it. I know that in Colorado they actually are using a test. There's still some question as to whether or not that test is as effective as it should be. But there's nothing currently on the horizon that exists at this point.
Well, you're going to be a very, very busy lawyer.
I'm used to that.
Your website has some very relevant blogs on the subject. It's shelleybrown.com, and it's SHELLEY brown.com.
Yes.
And I presume that's where people can connect
Yes,
with you if
absolutely.
they need a lawyer in this regard. Thank you so much for joining us this evening.
Thank you for having me.